Ladies and gentlemen, good evening, good afternoon, and good morning. On behalf of the organizers, I welcome you to this global workshop on the European AI Act, or the wider perspective on AI regulation. Great to have you here, and I would like to start by introducing our workshop. The idea behind the workshop is to have a comparative view on AI regulation, which is a global topic. Legislators in all parts of the world are currently discussing or already being active in regulating AI, and us, four institutions from four continents representing a good part of the legal traditions, decided to have a comparative analysis on the current state of AI regulation at the example of the European AI Act. And we are proud to have organized this workshop. Let me briefly talk about today's program. We will start with a very brief introduction of not more than 3 to 5 minutes to give full time to the four presentations from the speakers from the organizing organizations, as you can see. And most important, perhaps at the end, we will still have about half an hour for a discussion on all the four presentations and on our topic in general. And all of you are invited to actively join in the discussion. We organized a Teams meeting, which allows any one of you to make comments via the chat function, but also to join in the discussion by speaking later. Because the title was an old one from presentation I made last week. Let me briefly introduce myself. I'm Professor of Law at Saarland University and the Managing Director of the Institute of Legal Informatics at this university. I'm involved in legislation and on European level as a researcher, and also in some cases as a member of some EU expert groups, and I'm cooperating with the other organizing institutions for 3 years. In the third year, I'm distinguished visiting professor at University of Johannesburg, and this fall also visiting professor at Keio University. My home base, Saarland University, has been established 70 years ago. It's one of the smaller universities in the smallest of the German states, but as we proudly state, with the focus, having a faculty of law with a focus on Europe and technology. The Institute of Legal Informatics is involved in research on almost any area of technology and law, myself having a focus recently for the past decade in AI. We are also involved in education with, for instance, a master's degree in IT and law. And of course, the AI regulation, in particular the AI Act, is discussed there extensively. I hope to see some of you again in our annual international summer school, which we hope to be holding again in next year in summer 2025. Shortly, you would be able to receive some information via our website. So this is enough for the introduction, and the remaining 25 minutes I would like to use for a ride over the EU AI Act. What is this about? You will all know the EU AI Act, which came into force on 1st August 2024, so quite recently, 2 months ago, is the result of a legislative process that lasted for more than 3 years. It was very intensively debated in all of the European institutions, having a very intensive trialogue 1 year ago before the political agreement was finally reached. And even after that, in the so-called technical work, it underwent some important amendments. So at the end, we have a quite interesting and comprehensive piece of legislation here, which consists of 4 regulatory concepts with a very different direction. The first being the prohibition of certain AI practices. Second, and most important, covering more than half of the text, the protection or against high-risk AI systems. The rules provide for an extensive regulation of risk management for so-called high-risk AI systems. What a high-risk AI systems is will actually be the focus of my presentation as well. Thirdly, and most interestingly, the AI Act contains some transparency obligations for certain AI systems. And I said, very important, maybe most important and most interesting of all is that for the vast majority of all the AI systems, there are no requirements. It is assumed that more than 90% of AI systems are not subject to any legal requirements set forth by the AI Act. Instead, the AI Act offers rules on an infrastructure for AI development. So, which means that the AI Act aims to support the development and use of AI systems. To do this, the European legislator worked hard and finally came across with a massive law covering 13 chapters and 113 articles in the official gazette. The Act uses 144 pages, which is 50% more than GDPR. So it's a massive piece of legislation covering a lot of different areas. And I will just highlight a few of them. Before I do so, I would like to address the question why the AI Act is relevant and rightly being gathering some attention worldwide, just because it is applicable in big parts of the world. The AI Act provides for a super broad extraterritorial effect, meaning that it not only providers and users and deployers of AI systems established in the EU are covered, but also the providers, if you read the last paragraph, providers and deployers of AI systems having their place outside European Union are covered whenever the output produced by the AI system is used in the Union. This is very, very extensive, and it can easily be the case that an AI system that is used by someone established in Brazil, South Africa, or Japan, but providing a result that finally is used in the EU, be subject to the AI Act. Just one word on the timeline. The application over time is regulated in Article 113, providing for a very interesting 4-step approach. Most of the AI Act will be applicable in 2 years from now on, but the first chapter in not more than 4 months from now. The AI Act is applicable on AI systems and general purpose AI models. There is extensive literature and discussion on this term of an AI systems. To cut it short today, let me just describe it as software based on machine learning. The most important element here is that an AI system is characterized as software. as software. It's not hardware. So a self-driving car is never an AI system. It is a product containing a number of AI systems. A general purpose AI model is roughly described as the content of a neural network. So other than AI system, it is not as anything which can run a machine, but just the content which is the result of the training. I skip the exceptions for the sake of time and go on the addressees of the AI Act. The addressees of all of the duties under the AI Act are the provider and the deployer of an AI system. The provider is basically the developer of the software or the manufacturer, if you wish so, whereas the deployer is that entity that is running the AI system, so the operator. The AI Act also addresses importer and distributor of AI systems, however, just in the case where the provider is not available. So the main provider being, the main addressee being the provider. People not covered by the ASMS all are users of AI systems. So us using ChatGPT, for instance, are not covered at all. And also anyone who is using AI generated content is not covered at all. To give an example, if a German judge uses a legal text support that is developed by a company based in US to support, and that which is developed, distributed by a German system, and that system is run, let's say, by the German ministry, by a Ministry of Justice, in our case, Saarland Ministry of Justice, then we learn that the provider of that system is certainly LawTech in USA, since that has developed. The German judge is not addressed by the AI systems. However, the ministry that is running the system is considered as the deployer. As a result of the extraterritorial effect of the AI Act, LawTech is in full covered and addressed by the AI Act, as the system developed by it is to be used in Germany within the EU. As I said, the most important part of the regulation are the rules on risk management for high-risk AI systems. So I would like to explain what it is about. The chapter 3 on high-risk AI systems is divided in 4 sections, starting with the definition or reclassification of AI systems. And here the rules are really interesting. Article 6 provides for 2 totally different concepts of what an AI system may be. First of all, an AI system is a high-risk AI system if it is a safety component of a regulated product. Regulated products are products which are subject to European product safety legislation and which require a third-party conformity assessment, which means that in order to know if our AI system is a high-risk AI system according to this concept, you have to check if it is a safety component of a product. Second, if the product is regulated under European product safety legislation. And thirdly, if according to this legislation, the product requires a third-party conformity assessment. I stress the term third-party conformity assessments. This is the exception in product safety law. So at the end, the number of products covered here is rather small, but I can tell you that, for instance, some dangerous machines are covered. So AI systems for which are safety component of a dangerous tool will be covered here. The second concept, which is the real novelty here, is the concept of Article 6, paragraph 2, whereas where AI systems will be high-risk AI systems if they are used in so-called high-risk AI systems. And that is the case if two conditions are met. First, if the output of the AI system is used in a high-risk area. What a high-risk area is, a good question. I will come back to this in the next slide. And second, if that AI systems is creating specific risks to personality rights of third parties, so we have to undergo a second test according to Article 6, paragraph 3. The high-risk areas are listed in the so-called Annex 3, which has by 8 numbers different areas that are covered. And if you look over this list, if I refer you to number 3 and 4, education, vocational training, employment, then you can easily see that this is areas where we do assess people for candidate selections, for marking of student papers, and so on. And then we go on number 6, 7, and 8, where public administration and power is involved. And most interestingly, administration of justice, for instance, are in the play. Number 5 covers different essential services and reaches out to systems for credit scoring, for example, or for pricing in life insurance. I will try to illustrate this concept by an example, which is Frauke, which is a tool to support judges in flight right cases. What is Frauke able to do? It is having a function of text recognition, so it can read the attorney's pleadings in the case. It can extract information from them. It can compare this information with other information from databases, and is able to generate a text, in this case, a draft judgment. For judges, this is very useful tool. You just press a button and your judgment appears on the screen. This is fascinating. So is Frauke high-risk AI system? As Annex 3, number 8, clearly says that AI system to be used by a judicial authority to assist a judicial authority in researching and interpreting facts and the law and applying it to a complete set of facts, that is high-risk area. And no doubt Frauke is exactly doing this. So Frauke is used in high-risk area. We don't have time to go into detail here, but I just want to draw your attention to an interesting question, which is that Frauke is not such a sophisticated tool. AI is just used in the text recognition part. So funny enough, in all the end, text recognition is the AI part, and the question is that enough to characterize the whole software as a high-risk AI system? For reasons of systems such as Frauke, which fall within the areas of Annex 3, but do not contain machine learning based systems for decision making, mainly we have the second step or the second stage of the assessment according to Article 6, paragraph 3. And if you read the text of the article with me, you would see that an AI system which is covered by Annex 3 is not to be considered high risk if it does not pose a significant risk to fundamental rights of natural persons. And this is clearly the case, in my view, for Frauke. So Frauke would not be considered, in my view, as a high-risk AI system in the end. However, there will be certain AI systems which are indeed considered high risks, such as credit scoring or candidate selection by AI systems. In this case, the provider, so the developer of the high risk system, is subject to rules on risk management, which are quite comprehensive, and probably the most innovative and toughest one will be the rules on data governance, which, according to Article 10, which, among others, oblige the provider to have safeguards against bias, for instance, in the training data. And this is rather demanding, since identifying bias in training data is not an easy task at all. One interesting feature, which is also debatable to some extent, is the possibility of changing the rule from a deployer to provider according to Article 25. There are two ways where a simple deployer, so the operator of an AI system, can be considered provider and fall under all the duties of the provider. And the first of this is the customization of an AI system. Any material change of an AI system can trigger this change of role. And secondly, the change of a purpose of an AI system. And that is rather risky for operators. Just to use an example, if a judge would use an AI tool that has been developed for lawyers, then that would constitute a change of purpose, as the AI tool was developed for lawyers, not for judges. And as the use of AI tool for judges in the judicial process is high-risk area, that system would become high-risk system, and the court the judge is working for would be considered deployer, and then by virtue of this change of role under Article 25, be provider. That would be rather surprising for the court, I guess. And this is certainly a problem, since the deployer is not allowed to do anything with the AI system in a high-risk area. So customization and exploring new use cases for AI system in high-risk area would trigger the change of role and being an unacceptable risk. Therefore, any deployer would refrain from doing so. That's why I describe it as the deployer is forced into a consumer-like role. As I said, there is also an interesting part on transparency in the AI Act, and I would like to briefly mention it, at least, even though we don't have time to go into detail here. The transparency rules are laid down in only one article, Article 50, which has a number of paragraphs in it. And one of them, which is really interesting, is Article 50, paragraph 2, which obliges provider to ensure that the output systems are marked in a machine-readable format. This provision is very often referred to as watermarking of AI-generated content. And another one which seems reasonable but poses a lot of difficulty in understanding the legal concept is Article 50, paragraph 4, which obliges deployers of an AI system, so the operator of an AI system that generates content, to disclose that the content has been artificially generated if and only if that content is constituting a deep fake. So don't ask me at this moment what deep fake really is. There are lots of papers on it already. This is a challenge. One of the most interesting aspects are individuals' rights laid down in the AI Act. Article 85 grants the right to lodge a complaint for everyone. So everyone who feels that a deployer or provider is violating the AI Act can lodge a complaint with the authority. And what I find most interesting, the right to explanation according to Article 86, wherever a decision is taken on the basis of the output from a high-risk AI system, the affected person has the right to ask for an explanation reaching to the role of the AI system in the decision-making process and on the main elements of the decision taken. This is rather innovative and is worth more consideration, I think. What is not discussed a lot in public but is an important element of the AI Act are the institutional rules. The AI Act establishing not less than 4 new institutions on the EU level and 2 ones on the national level. Each of the member states will have to establish a market surveillance authority with important powers and going up to very high fines, for instance. As a part of the institutional rules, there are also interesting rules on standards and certifications, which are the cornerstone, the real cornerstone of the AI Act, and interesting enough, an interesting framework for self-regulation. The European legislator wishes to the economy to make use of the means of self-regulation to find appropriate rules, since most of the AI systems are not covered by any of the legal requirements. However, self-regulation is encouraged by the AI Act. In the last 2 minutes of my presentation, I would like to make a first interim conclusion on the European AI Act. As you will have seen via my rush over the AI Act and its different content, it is a huge act, however, not a conclusive legal framework for AI at all, despite this very general title. It's mainly a product safety law for AI systems. Even it is limited, it is still an important element of the legal framework for AI, as it offers infrastructure for development of standards for AI systems, as well as innovative legal concepts for AI regulation. I didn't mention in my presentation the EU database for high-risk AI systems, which is quite innovative in my view. I also would like to mention the rules on self-regulation and on transparency and explanation. There's someone which I would like to mute the microphone if possible. And having said this, I would like to draw your attention on what is not in the AI Act, but in my view still needed. We do need, in my view, rules on protection of developers and users of AI systems, directing, for instance, copyright for outputs from AI systems or other intellectual property considerations, such as the question if the use of content to train an AI model is infringing copyright or not. That's actually very important. And of course, third parties need protection against the AI systems, and in particular in cases where AI systems cause damage, such as a self-driving car, to make an example. What, in my view, will be in the longer run more important even is a framework for automated decision making. It is highly attractive to use AI systems for any kind of assessment of people, like applicants to an employment or to universities, to evaluate students or workers' personality or their performance and so on. And here we definitely need a legal framework. You also need urgently, in my view, a legal framework for automated communication. Just the example of political campaigns in social media triggered by AI systems, I think, makes it clear that we need something here which we don't have in place, at least not in Europe. When the legislator considers to be active in AI regulation, there are a lot of options. There are different areas where the AI regulation can be effective. The AI Act is addressing the development of AI system, nothing really more, but that's one important aspect, not the only one. Also, any legislator would have to consider whom to address, should it be, and which enforcement mechanisms should be provided. That's it from my part. Thank you very much for your attention. I think we still have 2 minutes for some questions.